Good evening. We are joined by Dr. Pawan Duggal. My first question to you is the Personal Data Protection Bill that was recently approved by the Cabinet. It has been in the works for about 6 years. The first draft of the bill was presented in 2018. Could you give us a brief history of this bill and what are the major changes that have been made or revised over the years?
Well, India has got a very checkered history as far as data protection has been concerned. Even today, when I talk, India doesn't have a dedicated law on data protection. We do not have a dedicated law on privacy, nor do we have a dedicated law on cybersecurity. So given this unique policy vacuum that's existing in the Indian context, India becomes a very fertile ground for the purposes of targeting data, individuals, and their digital activities in the digital ecosystem. It was keeping this thing in mind that the government felt the necessity for having in place a dedicated new legal framework on data protection. Now, it all started in terms of a journey way back in the year 2000, when the Information Technology Act 2000 was passed. This was India's mother legislation for everything in the electronic format. This was not a data protection law, but it did have certain provisions like Section 66 and 43, which dealt with some aspects of data protection. Come the Mumbai attacks in 2008, and we find that the government of India came up with the Information Technology Amendment Act 2008, which got passed by both the Houses of Parliament in December 2008. These amendments added in more elements of a lot of things, but also including of data protection. Consequently, they added Section 43A of the Information Technology Act 2000, where provision was made for unlimited damages by way of compensation should your data be not appropriately handled by a legal entity who's processing the same without following reasonable security practices and procedures, and as a result thereof you suffer losses, then you can actually seek damages of unlimited quantum by way of compensation. That was the year 2008. 2011, the government came up with the Information Technology Rules 2011. These were a set of 4 rules, including the more prominent being the Information Technology Intermediary Guidelines Rules 2011 and the Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011. They also put in various parameters for due diligence as also for data protection. But it was when the Aadhaar legislation, PIL, was going before the Supreme Court, the entire issue had come up because the Supreme Court wanted to find out what the government was doing on data protection. That's for the first time the government stated that we have now appointed a committee under the chairmanship of Justice Sri Krishna, a retired judge of the Supreme Court. That committee was straddled with the responsibility of coming up with a new legal framework on data protection in the Indian context. The committee gave its report in 2018, but along with the report, they also gave a proposed template of a Personal Data Protection Bill 2018 for the constitution of the government. The government examined the report as also the draft bill and said that a lot of things have to be added therein. The government made various changes and thereafter tabled the Personal Data Protection Bill 2019 before the Indian Parliament in December 19. That's the time the Parliament said that this is a very complicated bill, and therefore it must be going to a joint parliamentary committee. The joint parliamentary committee examined the bill for almost 2 years and came up with its report in December 2021. It actually suggested about 90 plus amendments that needed to be added in the Personal Data Protection Bill 2019. Now, once the government got the said report, the government took some recommendations, incorporated some changes, and came up with a draft Digital Personal Data Protection Bill 2022 for public comments. That draft Digital Personal Data Protection Bill 2022 was much more restricted, narrower version of the Personal Data Protection Bill 2018 and a far more narrower version of 2019 as well. So the various comments were asked for, the comments were received, the government examined those comments, and now the news has come that the Indian cabinet has approved the Digital Personal Data Protection Bill 2023. Now it's going to be presented before the Indian Parliament. The government has the numbers. If it wants, it can get it passed by a very, very quick move. And it's expected to be tabled before the Indian Parliament in the monsoon session of the Parliament in 2023. So in a nutshell, when one looks at this entire history, one sees various permutations and combinations and various new approaches that have been evolved over a period of time on data protection. Just to give one example, the Digital Personal Data Protection Bill 2018, which was recommended by Justice Sri Krishna Committee, had talked about data localization. There was a much more watered down version of data localization in the 2019 draft, but the 2022 draft almost gave up on data localization and wanted the Indian porous digital India economy to continue. So right now, we do not have access to the exact language of the Digital Personal Data Protection Bill, or DPDP Bill 2023, because it's not yet available in the public domain. So we'll have to wait and look at what the specific provisions are there in the DPDP Bill 2023, and then appropriate comments on the same could be potentially given.
This bill, when it first started, it had about 60 clauses, and now it is, I think, simplified into 30. Since this is a comprehensive, I think one of the first comprehensive law on data privacy, what issues or limitations does it have?
You see, we can only talk up to the last available draft, which is the draft Digital Personal Data Protection Bill 2022, on which I'm sure the new DPDP Bill 2023 would be based. So already the DPDP Bill 2022 was a great starting point, primarily because India has nothing on data protection in terms of a dedicated legislation. And India is getting more and more significant and important with each passing year. And that's the need that was felt by the Indian government and the Indian data stakeholders, that there must be at least some minimal regulation on data protection. Now, India has been very substantially influenced and inspired by the General Data Protection Regulation of the European Union. But the good thing is that the Indian lawmakers or the Indian policy draftsmen have tried to make incorporating of customized elements in the proposed bill. So when one looks at the bill for 2022, one found that that bill was of great significance because it elaborated the grounds for processing digital personal data. It gave immense primacy to the factum of giving notice to data principals to whom the personal data belongs. It gave tremendous emphasis on obtaining the consent of the data principal so that without their consent, appropriate processing or handling of data doesn't take place, specifically personal data. It also had come up with the concept of deemed consent. It had come up with certain provisions pertaining to general obligations of data fiduciaries. Further, it had specifically sought to provide some new grounds for processing of data that's belonging to children, that's below the age of 18 years. It sought to stipulate the various parameters of due diligence that have to be followed by both data repositories and also by data principals. Further, various rights and duties of data principals were sought to be enshrined under the last draft, which included the right to information about personal data, the right to correction and erasure of personal data, the right of grievance redressal, the right of nomination, and the duties of data principal. Further, it had come up with certain provisions pertaining to how transfer of personal data outside the territorial boundaries of India could potentially take place. It had also stipulated a kind of a new regime of compliances for data protection. It talked of a Digital Protection Board of India. It elaborated the various functions, duties, and responsibilities of the board. And it also sought to deal with connected aspects. So all said and done, the DPDP Bill 2022 sought to create some foundations on the basis of processing of, on the basis of which processing of personal data could take place in the Indian context. But how much of that gets reflected in the DPDP Bill 2023 is something that we do not know at the time of talking, because the draft Digital Personal Data Protection Bill 2023 has still not yet been released in the public domain. But we do hope that some of these elements would be substantially the building blocks for the DPDP Bill 2023.
So you have mentioned a lot of issues, and to address these issues, I think the bill calls for a creation of a data protection board. Could we have your opinion on the independence of this data protection board and how much power the government actually has in this?
Well, the Data Protection Board is going to be the creature of a statute, should these provisions of the DPDP Bill 2022 find mention in the 2023 draft. But while it's supposed to be an independent regulator of the data ecosystem, there has been, the last few drafts have invited certain objections and criticisms from some stakeholders who said that there is massive control of the government on the Personal Data Protection Board, which may render inadequate or ineffective the entire issue of efficacy or independence of the said board per se. Also, certain questions have also been raised pertaining to the transparency and accountability of the said of the Data Protection Board of India. Right now, the 2022 draft said that there was need for more checks and balances as far as the entire constitution of the Data Protection Board of India was concerned. But what is the specific language that the government has come up in 2023 draft is something that we'll have to wait till such time we get the draft in the public domain.
My next question is, what are the solutions to the problems in this bill, and how do you think this bill can be made more citizen friendly?
I think a number of things have to be done, but again, we can't really give suggestions till such time we have not read the bill, because giving suggestions on the basis of a previous draft, which has already been publicly commented, would not be appropriate. It's important to find out what is the specific essential parameters and building blocks of the DPDP Bill 2023, because only therein suggestions can be given. But clearly, as we go forward, we have to make sure that there's no conflict between the DPDP Bill 2023 and India's mother legislation on the electronic format, being the Information Technology Act 2000. That has to be a primary concern. Why? Because the Indian cyber law, being the Information Technology Act 2000, is the mother legislation under the umbrella of which various sub-legislations have come in. One of the sub-legislations is the DPDP bill. So that's the first thing that's important. Second thing, we are only going to be talking about personal data in the said law. But the personal data constitutes a small component of the entire data floating around in the data ecosystem. The entire issue pertaining to regulation of non-personal data is also going to be an important issue that should be weighing in the minds of the lawmakers. Number three, the entire concepts of data fiduciary, data principles, somewhere down the line could present in a lot of confusion. Why? Because Indian society has never really seen data as a valuable commodity. More so, these concepts are going to be in direct conflict with another very significant concept of intermediaries under Section 21W of the Information Technology Act 2000. There are a large number of chances that individuals will both be data fiduciaries and could also be intermediaries. Now, or organizations could have similar kind of, shall I say, legal standing. In such a scenario, we'll have to make sure that the rights, duties, and responsibilities for data fiduciaries that are going to be stipulated under the new law should not conflict with the right of the same entities and their duties as intermediaries under the Information Technology Act 2000 and rules and regulations made thereunder, including the Information Technology Rules 2021, which have been updated as on 6th of April 2023. Third, The entire personal data ecosystem has to be regulated in a manner so that the data constituents get effective remedies and access to them. Merely providing paper remedies is not going to be a good idea. Though there's information in the public domain that this particular new bill will be having fines up to 250 crore rupees to up to 500 crore rupees. These are, on the face of it, the highest possible known fines that have been stipulated under the law in India. But then merely having that on the paper book will not suffice. It will be imperative that they must be appropriately implemented. So a lot of things will depend on how the DPDP Bill 2023, as and when it's passed, is going to be effectively implemented. Fourth is that there must be adequate checks and balances that must be put up when we are specifically looking at more transparency and accountability. Also, the potential misuse or abuse of powers under the new DPDP bill have to be studiously avoided. And for that, again, if there are appropriate framework architectures issues that are incorporated in the proposed bill, that could also be a good starting point. And finally, I think as a nation, we will have to try to find that the new legislation comes up with a golden balance between two competing interests. On the one hand, the interest of the individuals to protect and preserve their personal data, and on the other hand, the interests of the sovereign government to go ahead and have access to data as part of their electronic governance or even sovereign functions requirements. So how does the DPDP bill go ahead and deal with all these are important issues that only time will be able to tell whether they'll be addressed or not.
What is your opinion on some of the vague provisions or like provisions that are made on the fact that the government is exempted on this data protection law under certain circumstances? And how do you think this can be implemented further?
Every sovereign government wants that there must be some exemptions because they have to deal with data of individuals, of citizens, and the said dealing is necessary as part of performance of their sovereign functions of governance. But having said that, giving carte blanche freedom or blanket exemption to the government from the applicability of the data protection law is something that's undesirable. So there will have to be appropriate checks and balances. If there are going to be certain circumstances under which we will find that the government is being exempted from the applicability of this DPDP Bill 2023, then it's very imperative that they must be crystal clearly defined in the narrowest possible terms. Why? Because if the law and the legal components therein are put in vague, broad, general, or ambiguous kind of a language, then it's going to bring in a lot of uncertainty. Also, the very element requirement of transparency and accountability could be prejudicially impacted if these kind of gray zone, or shall I say, ambiguous provisions are going to be put in place. So we don't exactly know under what conditions are government going to be exempt from the applicability of the DPDP bill. Again, we have to wait for the text of the DPDP bill to read through the same before we comment on the same. But somewhere down the line, that golden balance is something that must be achieved by the proposed legislation. The government should not have a free hand to go ahead and trample upon people's liberties. On the other hand, the government's hands should not be so well restricted that they cannot even do legitimate work that they need to do in terms of dealing with data. And they should not be seen that the DPDP bill actually becomes more a kind of a hindrance or deterrence in the form of the government performing its day-to-day governance activities. Again, we'll have to wait for the final draft of the DPDP Bill 2023 before we can comment on this issue.